They're over your head.
Gotcha.
You see, you're scared now. You're going to be scared later. I'm glad you reacted that way because it is a scary thing. 6 months in jail.
Yeah, I don't want to spend 6 months in jail.
Figure it out. We will go on the record in the matters. 24 TR 718, 24 TR 719, 727, and 922, 23 CF 165, 24 CF 168, 24 CF 240. State of Wisconsin versus Tina Sally. The state appears through District Attorney Kevin Schmidt in person. Ms. Sally appears in person with her counsel, Joseph Rosenthal. We're set today in these matters for pleas and sentencings. Mr. Rosenthal, can you please update the court as to the agreement that has been reached?
Yes, Your Honor, thank you. My client would enter a plea of guilty to an amended count 1 simple possession in 23 CF 165. Counts 2 through 5 would be dismissed and read in. In 24 CF 168, my client would enter a guilty plea to count 2 felony bail jumping. Counts 1 and 3 would be dismissed and read in. 24 CF 240 would be dismissed and read in its entirety. And I believe there is an agreement to dismiss the traffic citations. And both sides would be free to argue. I'm sorry.
What's free to argue? And Mr. Schmidt, I'm going to guess that, and just correct me if I'm wrong. The reason for the public interest for the amendment from possession with intent methamphetamine down to simple possession of methamphetamine is simply because Ms. Sally was at her place of employment and offered someone else the paraphernalia with the methamphetamine in it to take what I would describe as a hit or to use it. And so that's why it's being amended to simple possession.
If the court wants to know the public interest on it, as the court recalls from the PC statement, also in the police report, this was actually referred as simple possession by St. Croix Tribal. DA Renicky charged it as a possession with intent or delivery. He's technically right. That does constitute delivery for the same reason that a bunch of kids passing around a joint in a school circle, like from that 70s show, that would be delivery as well under Wisconsin law. All laws are overly inclusive or underly inclusive. Therefore, it's up to the judgment of people like myself and you, Judge, and Mr. Rosenthal to figure out, you know, when the laws are overly or underly inclusive, what to do there. There's a situation where she just offered someone drugs. They took it for peer pressure reasons. They didn't use it. They reported it to their supervisor. No money exchanged hands. I don't have any information. Tina's, you know, dealing drugs anywheres. So that's the reason why.
All right, thank you.
And also, Judge, the quantity was like infinitesimally small. I don't even think it was like like 1/10 of a gram. The lab results said like 0.07. So it's just in terms of quantity, you know.
It was very small. The officer wrote in their report it was too small for them to even measure on their scale.
All right. Okay, thank you. Satisfies the court. Formal motion to amend count 1 and 23 CF 165 to simple possession and I felony.
So made.
Granted. All right, Miss Sally, that's the agreement that you've reached with the state. Is that true?
Yes, ma'am.
I have in front of me 2 plea questionnaires, waiver of rights forms. They're identical, except for the charge that you're pleading guilty to and the case numbers. Did your attorney go over, well, and the maximum penalties? They're different too, but as to what those documents state and the form itself, they're identical. Did your attorney go over this form with you thoroughly?
Yes, ma'am.
Did he essentially go over it with you word for word?
Yes, ma'am.
And did you sign both of these documents?
Yes, ma'am.
And do you understand them completely?
Yes, ma'am.
And if you didn't understand something, did you ask him to explain it?
Yes, ma'am.
And he did so?
Yes, ma'am.
So you understand everything in these documents?
I do, ma'am.
All right. Now, you were pleading guilty to 1 count of simple possession of methamphetamine and 1 count of felony bail jumping. You're 49 years old. You have 10 years of schooling. You can read, write, and you understand the English language. Is that all correct?
Yes, ma'am.
You do not have a high school diploma or equivalent. However, like I said, you can understand everything that's going on, right?
Yes, ma'am.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt as to these two charges?
Yes, ma'am.
Did your attorney go over with you the maximum possible penalty you're facing?
Yes, ma'am.
You are not receiving treatment for mental illness or disorder, and you've not had any drugs, alcohol, or medications in the last 24 hours. Is that correct?
Yes, ma'am.
Because you're charged with crimes, you are entitled to constitutional rights, and those rights are listed on those documents. Next to the rights is a box, and each of those boxes is checked. That tells me your attorney went over those rights with you. You understand those rights, and you understand that you're giving up those rights by pleading guilty. Is that all true?
Yes, ma'am.
Do you need me to go over those rights with you in any more detail?
No, ma'am.
So you understand those rights completely.
Yes, ma'am, I do.
You understand that if you're not a citizen of the United States, your pleas could result in your deportation.
Yes, ma'am.
You understand that you're pleading guilty to felonies. As such, you will no longer be able to use or possess a firearm for life.
Yes, ma'am.
You will no longer be able to vote in any election until your civil rights are restored.
Yes, ma'am.
You understand that the state would have to prove in 24 CF 168, the felony bail jump, that on or around July 14, 2024, in Burnett County, Wisconsin, having been charged with a felony in Polk County case number 22 CF 171, and having been released from custody, you intentionally failed to comply with the terms of your bond by possessing illegal drugs, substances, or paraphernalia, and you did not have any valid prescription to possess any of the items you had. Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand the maximum possible penalty could be up to a $10,000 fine, 6 years of incarceration, or both?
Yes, ma'am.
You understand that in 23 CF 165, count 1, amended to simple possession of methamphetamine, an I felony, the state would have to prove on or around September 9th, 2023, you possessed a substance. The substance was a controlled substance, methamphetamine, and that you knew or believed that substance was a controlled substance, methamphetamine. Do you understand what the state would have to prove?
Yes, ma'am, I do.
Do you understand that upon conviction, you face up to $10,000 fine, 3.5 years of incarceration, or both?
Yes, ma'am.
You further understand that there is an agreement here for what's called free to argue. Do you understand that means that each side is free to argue any sentence recommendation to the court that they wish and they desire? Do you understand that?
Yes, ma'am.
Do you understand? I'm not bound to follow any of those arguments. I don't have to follow the states. I don't have to listen to the defenses. I must listen, but I don't have to follow. And that I'm free in my own discretion to sentence you to what I believe would be a fair and just sentence for these cases in my discretion only. Do you understand that?
Yes, ma'am.
And that could be the maximum possible penalties. Do you understand that?
Yes, ma'am.
Do you still wish to proceed and enter guilty pleas?
Yes, ma'am.
Do you have any questions for the court or your attorney before I proceed?
No, ma'am.
Did you go over the criminal complaints in both of those cases with your attorney?
Yes, ma'am.
In particular, there's sections called the probable cause sections that basically say what happened those days and why you were charged with the crimes. For the most part, are those facts accurate?
Yes, ma'am.
Are you admitting here today that on or around September 9th, 2023, you in fact did possess methamphetamine
Yes, ma'am.
and you knew it was methamphetamine?
Yes, ma'am.
Are you admitting here today that on or around July 14th, 2024, that you knew you were on felony bail jump, or you knew you were on felony bail with certain conditions and bond in Polk County on a felony case, and that you intentionally violated that bond and those conditions by possessing illegal substances?
Yes, ma'am.
Mr. Rosenthal, may the court use the probable cause sections along with the statements made by your client to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to these two charges?
No, ma'am.
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing here today
Yes, ma'am.
and voluntarily.
Yes, ma'am.
Has your attorney represented you competently?
Yes, ma'am.
Has he answered all of your questions?
Yes, ma'am.
Has he looked at these matters thoroughly?
Yes, ma'am.
Has he discussed with you any potential for legal defenses, or has he said you have no defenses or little defenses in this case?
What does that mean?
The question is whether I've advised you
Oh,
on whether there's any
yes, ma'am.
defenses or not.
Yes, ma'am.
Talk to you about whether or not you have
Yeah.
any defenses?
Yes, ma'am.
And what, if you go to trial, what could happen?
Yes, ma'am.
Are you satisfied with the services?
Yes, ma'am, I am.
Any questions for the court or your attorney before I proceed?
No, ma'am.
As to 23 CF 165, count 1, simple possession of methamphetamine, and I, felony, how do you wish to plead?
Guilty.
As to 24 CF 168, count 2, felony bail jumping, and H, felony, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find that you understand and that there is a factual basis. I will dismiss and read in all other counts and cases and open matters. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Sure. Checking one thing. Yep. What I would ask the court to do is sentence to Miss Sally to 2 years probation, either withheld sentence or a state and imposed sentence. If it does a state and imposed sentence, I think it should be 9 to 12 months on each concurrent. I don't think the conduct merits prison. Normally I'd say 6 months state and imposed, but I do think the giving of the drugs is worse than just possessing it. For conditions, I think the court should order not to possess drugs with or without a prescription or drug paraphernalia, not to have contact with any known users or dealers except as necessary in a treatment or confinement setting, follow rules of supervision, AOD and follow through, and ability to petition for early discharge once all conditions by probation are complete. I'm just reading this straight off of what she was sentenced to in Polk County. I want to mirror the conditions. In Polk County, the basis of the felony bail jump is she was on a deferred agreement for meth and THC. These cases caused that to be revoked. Our cases are meth and THC, so they're really tightly, heavily linked together. So if the court follows what I'm suggesting, it'll just extend her probation by like 2 months, 2 months longer than just the Polk on its own.
Is
But
Polk
it-
withheld?
What?
Is Polk withheld?
They did withheld. I just know the court's preferences for state and imposed, which is why I gave the alternative there. I think she reflects a substance abuse issue. The one condition I would add that Polk doesn't is to get a valid license because of the OAR. Her history is substance abuse. That's what she needs help treatment with. She is obviously capable of being a productive member in society. She was working at A&W when this happened. Thank you.
All right. Mr. Rose, go ahead.
I was just gonna say the Polk case is 22 CF 171 if the court's curious about looking at it.
I'm pulling it up right now.
And obviously ours concurrent to Polk. I meant to say that too, sorry.
Yes. All right. Mr. Rosenthal.
Thank you, Your Honor. We would ask for a slightly less term of probation, 18 months. I do think she's a very good candidate for probation. She's made all her meetings with her agent. She was, at the time of the first case, she was working at A&W. After that, she was working at the poorhouse for a number of months. That's kind of on hold right now. She had a bit of a situation with her significant other that she had to get out of. So, and I think to her credit, she made some healthy choices there. She's, now living up in Minot with her brother. She's informed probation of the change of address. She's informed the clerk of the change of address. Again, this was kind of a situation that was, made, I think it was her kind of being proactive and being healthy and getting out of something that was not particularly, in her best interest. Also to her credit, she stayed in very good contact with me throughout the pendency of these cases. You know, even just a few days ago, she called me, she said, hey, look, you know, I don't have a ride down to court. I said, hey, Tina, no problem. I'll come and get you on my way from Superior. You know, I'm always willing to go the extra mile for my clients. Again, this is just a reflection on her character of being responsible to both probation and to making sure she shows up to court on time, is not driving without a license, those type of issues. So, you know, again, I agree with the state, you know, she's got a track record of being a productive member of society. I do view this as a rehabilitation case. You know, again, I mean, we're talking about, you know, a very small quantity here that was already discussed. In terms of it being less than 1/10 of a gram of methamphetamine. The THC, I believe, was a cartridge. So it's, you know, it's personal use, no allegations of, well, there was an allegation, but it's been amended. You know, there's no facts to support, you know, dealing or delivery. So that is, I think, all to her credit. Again, we'd asked for a slightly less term of probation. She's been in compliance, you know, I mean, you know, she's had her ups and downs, but, you know, probation's willing to work with her, you know, even with these 2 cases, you know, they didn't elect to revoke. So I think for those reasons, Judge, we would ask for 18 months with a withheld sentence.
Thank you. Ms. Sally, do you want to provide a statement to the court? You don't have to, but it is your only time to fill me in. Let me know what's going on.
I'm just trying to find a ground to stand on, Your Honor, so that I can get my license back and get back on track. I had to get out of a situation, and I'm starting from the bottom and I'm going back up. I just want to continue to contribute to the society, you know. I mean, I'm not trying to be a problem. I'm not trying to be out there using drugs. I just want to live and be comfortable. I'm sorry about wasting the court's time and all that. I just want to get this done so I can move on.
I appreciate that, Miss Sally. I truly do. I truly do. Everybody says it. I'm going to tell you, everybody says, I'm sorry for wasting the court's time.
I really am, Your Honor.
No, I want to say it's not a waste of court's time. Cases are not a waste of time. A, it's my job. B, it's the law. And that's why we're here. And when you say it's a waste of court's time, essentially what I hear is, when you're saying it, that you think that you're a waste of time. And I understand that you mean what you did, you shouldn't have done.
That's exactly what I mean, Your Honor.
And I get that. Truly understand, and I get that. Miss Sally, I think this is the first time I've seen you in front of me for things other than driving without a valid driver's license. Quite honestly, if I'm thinking back to 2017 when I first stepped on the bench, my number one objective, well, A, I want you to be clean and sober. I want you down that path. B, I want you to get your driver's license.
I just had it.
Yeah, you did.
I lost it because I missed one class.
Why?
I didn't know I had to finish the class. That is honestly my mistake, and I have to start it over, but I'm going to get it done again.
So you got to get it done again.
I'm going to get it done again. I'm already on the path to doing that. I just got to do my AOD again and start over, and it will be done again, all the classes.
And that's a bummer, because then you have to repay the AODA.
Mhm,
You have to
that's
start
all
the
I'm
classes
doing.
Again, 1, 2, 3, and keep going. You have to keep
Yes,
doing
ma'am. That's what I'm on right now.
that. Sally, I have certain things I have to look at when sentencing. One, how serious is the matter? Is this serious? It is. It's methamphetamine. And you were on felony bail and bond from Polk County for similar types of issues and matters, substances, illegal substances. Then I have to look at you individually, Miss Sally, your character, your past criminal record, needs for rehabilitation, those types of things. I know you. I don't know you well. I know you in the context of how you've been here in court throughout these years. I don't think you have a bad bone in your body. I don't think you're out there to hurt people. You're hurting yourself. That's what you're doing. You're hurting yourself.
Can I say one thing, Your Honor?
Yes.
When I was working at A&W, okay, I was standing in the bathroom with the manager and I found something laying on the toilet paper rack and I handed it to the manager. 2 days later, I got arrested for giving her drugs. I had no idea what it was. I didn't know what it was. It was just a little container. I shook it and handed it to her, Your Honor. I had it in my possession for 5 minutes and I just started work there. I'm not gonna go giving my boss drugs. I don't do methamphetamine, okay?
Well, then,
And so I was fighting it.
then if you're telling me that I just took your plea and you admitted to possessing methamphetamine, and you're saying that it really wasn't yours and that it was this innocent thing.
It was in my possession, though.
I get that. I truly understand that part. I understand possession and legal possession. I don't like to take pleas of people who are not really committing the law that they're pleading guilty to.
It was in my possession, so I had
That's not
to.
the facts of the case as they were laid out in the complaint. That's not how it was presented to the court in the criminal complaint or how it was told to the police. It just wasn't.
I told it to the police, but I never got a chance to say anything to anybody.
If I'm remembering correctly, didn't it happen on a break and you offered something?
No, ma'am.
Break?
I was at work online when I got pulled offline 2 days, 3 days later after I had found it in the bathroom and gave it to the manager. I don't even know the manager's name. And I didn't have it on my possession. I just got arrested offline because she said I gave her drugs. She said I gave it to her that day. Your Honor, I didn't give it to her that day. I even went home and told my family about it. But it was in my possession, so I should have got rid of it or threw it away or flushed it or whatever it was, but I gave it to my manager. And because of that, it was in my possession and I gave it to her. So I gave her drugs.
That's all true.
So that's,
All facts. You were in possession, but
And-
it wasn't in. So if I test it here today, you're not going to test positive for methamphetamine?
no, ma'am.
I need to look at your Polk County case. That's what I need to do.
And I believe she's probably being drug tested anyways, since she's on probation for methamphetamine out of Polk.
Yeah, and see, and there's those allegations of possession of methamphetamine in Polk County as well. And so, Miss Sally, I want to believe you. I truly do. I truly want to believe you. But then we have Polk County case number 22 CF 171, and you pled guilty to possession of methamphetamine, possession of THC. It's a story. It could be plausible. But based upon the facts of the criminal complaint as they're laid out in that criminal complaint, that's not how it happened.
That's fine, Your Honor.
That's not how it happened.
That's fine, Your Honor.
And that's all I get. I don't get discovery. I don't get to talk to witnesses. I don't get to look at anything other than the criminal complaint and information and arguments by both sides.
That's fine, Your Honor. I understand my charges and I'm willing to move forward.
What happened in Polk County then? If you were charged with possession of methamphetamine, you pled guilty.
It was in my possession. So I pled guilty.
You were in possession of methamphetamine
Yes, I was.
on April 21st, 2022 in Polk County.
I
You pled guilty to it, so you must have
I
been
must have been, yes. I pled guilty.
guilty once, guilty twice.
Mhm. I take my charges, Your Honor.
All right. Not candy.
No, ma'am.
You know, can't just like hold it for somebody and then pass it on, and not a pen. Miss Sally, I don't know. I don't know what you need, because all I know that you've been in front of me for on previous occasions, other than these cases, driver's license. And these other matters are serious. I need to look at protecting the public, and I understand Mr. Schmidt's argument that this is a bit more serious than a simple possession if this is something of delivering or giving to somebody else. And I can't weigh credibility because I don't have the other individual providing me testimony versus your testimony. So I can't weigh any credibility of who's telling the truth with your story or the other story. The police went forward, they interviewed all parties. It's put forth in a police report. The criminal complaint is generated, and that's what's provided to the court. So that's what I have. So probation is necessary and it is appropriate. And your probation started in Polk County, August 6, 2024. And it looks like it was for 2 years, so it'll run through August of 2024, apparently. Mr. Schmidt is asking that you stay on for about 2 years. I don't know what else you can gain for a few more months after your Polk County. Because I'm going to be blunt and I'm going to be straight. Either you're going to follow probation and you're going to do what you need to do and you're going to figure this stuff out, or you're not. And either you're going to do it right away or you're not. It's not usually the last 2 months of probation where people mess up. It's usually right away or sometime in the middle, not the last few months of probation. By then, either they figured it out or they've already been revoked or looking at revocation. Probation is appropriate. I'm going to follow Mr. Rosenthal's recommendation of 18 months of probation, concurrent with Polk counties. With regards to sentences, I understand the delivery argument. I didn't write down what you said. You argued for a year.
I said between 9 months or 12 months because I thought it was more serious than 6 months, but not
Not
a true delivery.
It's definitely not a prison case. Anyway, shape or form, neither of these cases are a prison case. But you should know your penalty and your punishment. You got to figure it out. Even THC, marijuana in the state of Wisconsin is illegal, Miss Sally.
Yes.
You cannot use or possess at all, any way, shape, or form, THC marijuana. You can't. You want to use it? Go on over to Minnesota. They're really close. Move on there. Go to Michigan. Go on there. Go on down to Illinois. Go down there. But you can't stay here. I don't see the law changing anywhere anytime soon in Wisconsin. So with regards to these two cases, I understand Mr. Smith's argument that it is more serious, but I don't believe that you have a severe criminal history, and I've not heard that you have a significant criminal history. There should be a punishment. And again, I can't go off of credibility because I don't have two stories here to determine who's really telling me the truth. So with regards to 22 CF 171 count 1, I'm sentencing you to an imposed and stayed sentence of 6 months of incarceration.
You're not doing
Not
that right
now,
away. That's
not
just imposed
today.
and stayed,
It's hanging
okay?
over your head.
Yeah.
What case number was that?
For both of them, it doesn't matter.
165?
Yep. And for 23 CF 165, 6 months of incarceration imposed and stayed. They're over your head.
Gotcha.
You see, you're scared now. You're going to be scared later. I'm glad you reacted that way because it is a scary thing. 6 months in jail.
Yeah, I don't want to spend 6 months in jail.
Figure it out. Miss Sally, figure it out.
I'm working on it, Your Honor. I really am. I got out of a situation and I'm on a roll.
And I'm glad. And this means no disrespect at all. I mean, no disrespect when I say this.
Mhm.
It looks like you've put on a little bit of weight.
I have,
That's a positive thing.
thank you.
That's a good thing. That tells me you are now taking better care of yourself.
I am, Your Honor, thank you.
So that's why I say no disrespect. Women usually don't like to hear that they've gained weight, but this is a positive thing.
Thank you, Your Honor. I didn't think anybody noticed.
So while on probation, no use or possession of any illegal drugs, substances, or paraphernalia. No bars, taverns, liquor stores, casinos, or establishments that have the primary purpose for the sale or the service of alcohol, except for work-related matters.
Got you.
AODA assessment and follow-through, get your driver's license, regular testing, no use or possession of a firearm for life, no voting in any election until your civil rights are restored, no alcohol. I'm going to also say no contact with anyone on felony probation or felony extended supervision for drug-related charges and convictions without agent approval, except in treatment or if you're incarcerated, obviously. $443 and no, $518 in fines and fees per count. You have 20 days to appeal. Should you fail to appeal within 20 days, you lose that right. Civil judgment, if you fail to pay, you're always going to owe it. If you don't pay, I'll issue a warrant. You could sit up to 6 months in jail. I'm very harsh. You should know that. I follow who pays and who doesn't.
I know.
People sit in jail if they don't pay. I need your DNA. When you're done here, you're going to go and provide it to the sheriff's department. You have the ability to request it be expunged through the written letter through the Department of Justice. Not me, not the county, the Department of Justice. It looks like I need fingerprints in 24 CF 168. You're also going to need to give fingerprints in that file. I need them in every file. What am I missing, Mr. Schmidt?
One, did the court say get a license as one of the conditions?
I did.
Mhm.
And two, because Attorney Rosenthal expressed uncertainty about at the beginning, we are dismissing but reading in all the traffic tickets, including the Village of Siren ones. I have authority to do that from Adam Benson.
Yes, everything else that's open.
Okay.
What am I missing?
I may have missed it, Judge, but was there concurrent language on both counts if revoked?
Yes.
Okay.
Current.
Okay.
All right. Then we are adjourned. Thank you.
I'll go downstairs.
I gotta.
Yeah, you gotta get some paperwork here.
Yeah, I can run downstairs.
A Wisconsin courtroom falls silent. A woman stands facing years of consequences. Felony bail jumping, simple possession, small quantity, big consequences. The judge listens carefully. The law is clear. Intent does not always matter. Possession is enough. Probation is granted, but prison still hangs overhead. 6 months stayed, 6 months waiting, one mistake away. Fear is visible, and fear is the lesson. This court believes in accountability, but also in second chances, rehabilitation over incarceration, structure over chaos. The warning is simple: figure it out, or jail will. This is not drama. This is real-life justice in Wisconsin.